Namaskar. Continuing with our video series on the refresher training manual on execution matters for the staff of district courts at Punjab, Haryana and UT Chandigarh. Today we shall look into part 5 of chapter 4, which deals with execution by way of sale. So let me take you to the said chapter. Execution by way of sale. Any court executing a decree may order that property attached be sold entirely or such portion thereof as may be necessary to satisfy the decree. Order 21, Rule 64 CPC. Any court can order the sale of the property of the judgment debtor in execution of the decree. Every sale and execution of a decree shall be conducted by an officer of the court appointed by the court and shall be made by public auction. Order 21, Rule 65, CPC. Court officials for conducting sale. Volume 1, Chapter 12, Part L, Rule 20 of Rules and Orders says that sales in execution of decrees shall ordinarily be conducted by the court auctioneer. The district judge may direct by special order that the sale in a particular case or cases shall be conducted by the Nazarat staff. Sale by court auctioneer. The district judge of each district shall, with the prior approval of the High Court, appoint a court auctioneer to conduct sale and execution of decrees within the limits of subdivision. The official receiver shall ordinarily be appointed as the ex officio court auctioneer for the subdivision which has its headquarters at the place where the headquarters of the district are located, substituted by correction slip number 26 dated 17th September 1976. Sale by agents of court auctioneers, Volume 1, Chapter 12, Part L, Rule 21, 2 of Rules and Orders. The court auctioneer may employ his agent for conducting the sale of the property of which estimated value is rupees 500 or less. Such sales shall be conducted under the general supervision of the court auctioneer, and he shall be responsible for the proper compliance with all legal requirements. The court auctioneer shall each morning supply to each court a date sheet showing the sales already filed by all the courts in order that sales which he has to attend may not be fixed at different places on the same day. Sale by Nazarat staff, Volume 1, Chapter 12, Part L, Rule 24(1) of Rules and Orders. The proper officer to conduct the sale in such cases will be where the sale is ordered by the Court of Small Causes, any officer appointed by the court who could be from department. When the sale is ordered to be conducted by a court other than the Court of Small Causes, the Civil Nazir. For all sales ordered by courts located at district headquarters and for all other sales in which the value of the property to be sold is estimated to exceed rupees 5,000. The Naib Nazir for other sales, and in every case in which the Civil Nazir is not required to conduct the sale in person, such sale may be conducted under the orders and upon the responsibility of the Civil Nazir by a Naib Nazir deputed by him. Execution bailiff in cases where property is of small value, Nazir or Naib Nazir is not available and sale is to be conducted at the place where the attached property is situated. Process server in cases where no other officer as aforesaid is available and when value of the property to be sold is estimated to be rupees 100 or less. Procedure to be adopted. Step 1. Issuance of notice for settlement of proclamation, Volume 1, Chapter 12, Part L, Rule 2 of Rules and Orders. Whenever sale and execution is ordered by the court, it shall further cause a proclamation of sale to be made. Order 21, Rule 66, Sub-Rule 1 CPC. Before issuing such proclamation, a notice to the parties be given. Order 21, Rule 66, Sub-Rule 2 CPC. However, when a notice under Rule 54 of Order 21 has already been given for the date for settling the terms of the proclamation, it shall not be necessary to give notice under this rule unless the court otherwise directs. Under Order 21, Rule 54, Sub-Rule 1A CPC, the court shall, along with the attachment order, direct the judgment debtor to attend court on a specified date to take notice of the date to be fixed for settling the terms of proclamation. If the property ordered to be sold by the court is not the land assessed to land revenue paying or revenue free land or any interest in such land, the court shall fix a convenient day not being distant more than 15 days for ascertaining the particulars specified in Order 21, Rule 66, Sub Rule 2 CPC. Notice of the said day shall be given to the parties or their pleaders. Where the property to be sold is movable property which has been made over to the custodian under subclauses A or C of clause 1 of rule 43 of this order, the court shall issue a process by way of a notice to custodian directing him to produce the property at a place of sale at a time to be specified therein, with a warning that if he fails to comply with the directions, he shall be liable to action under section 145 of CPC. Order 21, Rule 63, Sub Rule 3 CPC as amended. Helmuth shall, on receiving the order from the court, issue notice to the JD on proforma number 28, Appendix E CPC. For the ready reference, we have also provided with the proforma number 28, which is the notice of the day fixed for settling a sale proclamation under Order 21, Rule 66. When the judgment debtor has already died, then as per order of the court, Helmuth shall issue notice to the legal heir or his representative on proforma number 99, Appendix E CPC, which is as follows. We again have given the proforma number 99, which is the notice to the heir or representative of the judgment debtor under Order 21, Rule 22, Sub Rule 1 of the Code of Civil Procedure, form prescribed by the High Court. This is that proforma. Step 2, Inquiry into Encumbrances, Volume 1, Chapter 12, Part L, Rule 3 of Rules and Orders. Before issuing the order for service of proclamation of sale, the court may hold an inquiry as to the encumbrances over the property to be sold from the sub-registrar's office. The expenses of the said inquiry shall be recovered by Helmuth or execution clerk from the decree holder as per the rates prescribed in the second proviso to Article 2 of the Table of Registration Fees published with Punjab Government Notification Number 22850 dated 25th September 1923 as amended by Punjab Government Notification Number 23759 dated the 15th June 1932, which are as follows. For the first year in the books of which search is to be made for each entry or document, ₹1. For every other year in the books of which search is continued for each entry or document, rupee 25 paisa. The fee in each case is subject to a maximum of ₹5. The amount recovered in this behalf by Helmuth or execution clerk will first be placed in deposit and will then be paid to the registration department by means of repayment vouchers endorsed in their favor. The report of the sub-registrar shall be open to the inspection of the parties of their pleaders free of charge between the time of its receipt by the court and the settlement of the proclamation of sale. Step 3, Settlement of Proclamation of Sale, Volume 1, Chapter 12, Part L, Rule 4 of Rules and Orders. The court shall, after perusing the documents, if any, filed by the parties and the report referred to in Rule 3 of the sub-registrar, and after examining the parties, settle the proclamation of sale. Step 4, Settling 4 dates as a matter of practice after conducting the above said inquiry. The court settles the terms of proclamation and grants 4 dates as follows. Notice at the spot, pasting the notice at the courthouse, date of auction sale, report. Note, there should be a gap of at least 15 days in the case of immovable property and of at least 7 days in the case of movable property between the date on which the copy of the proclamation is affixed on the courthouse of the judge ordering the sale and the date fixed for auction. High Court Notification Number 125, Gazette 11, Y14, dated 7th of April 1932, Rule 68, Order 21 CPC, substituted by the Code of Civil Procedure Amendment Act 1976. Step 5. Issuing order on Nazir. On receiving the orders of the court after the settlement of proclamation, Elmad or execution clerk shall issue the order on the Nazir as per performer number 30, Appendix E CPC, which is as follows. We have again provided the order on the Nazir for causing service of proclamation of sale under Order 21, Rule 66, as per performer number 30 in our manual, and this is the performer. Step 6. Issuance of proclamation of sales. Thereafter, the proclamation of sale shall be issued by Nazir on proforma number 29, Appendix E CPC, which is as follows. We have again given proforma number 29, that is proclamation of sale under Order 21, Rule 66 in the manual. Points to be noted before issuing a proclamation of sale. The proclamation of sale shall be in the language of the court. The date, time and place of the sale shall be clearly stated. Specific description of the property or part of it which is ordered to be sold shall be given. The revenue assessed where the property to be sold is an interest in an estate or in part of an estate paying revenue to the government shall also be mentioned. Any encumbrance to which property is liable shall be mentioned. The amount for the recovery of which the sale is ordered shall be mentioned. Any other thing which is material for purchaser to know to judge the nature and value of the property shall be mentioned. The particulars to be entered in the proclamation for sale shall be entered carefully in order to remove any objection to the sale at a later stage. It is not necessary to mention the court's estimate of the value of the property. It is sufficient to include in it the estimate, if any, given by either or both the parties. Proviso added to Order 21, Rule 66, Sub-Rule 2, Clause E by the Punjab High Court. High Court Notification number 567, Gazette dated 4th of November 1929 and number 150-R/11-Y-14 dated 16th May 1939. Note: Elmad or execution clerk shall obtain the signature of the judge over the proclamation after it is prepared. Elmad or execution clerk shall prepare 4 copies of the proclamation. Step 7. Mode of making proclamation. Order 21, Rule 67, read with Rule 54, Sub-Rule 2, CPC. The bailiff on receiving the proclamation shall serve it in the following manner. Announce the proclamation at some place on or adjacent to the property by beat of drum. A fixed copy of the proclamation on a conspicuous part of the property to be sold. Paste upon a conspicuous part of the house of the courthouse or a copy of the proclamation. Where the property is land paying revenue to the government, the affixation is to be effected in the office of the collector of the district in which land is situated. And when the property is land situated in a village, affixation is also to be effected in the office of the Gram Panchayat, if any, having jurisdiction over that village, inserted by the Code of Civil Procedure Amendment Act 1976. Where the property is land situated in cantonment, copies of the order shall also be forwarded to the cantonment board and to the military estates officer in whose area that cantonment is situated. Volume 1, Chapter 21, Rule 63 of Rules and Orders as amended. The order shall take effect as against persons claiming under a gratuitous service from the transfer from the judgment debtor from the date of the order of attachment or from the date of proclamation, whichever is earlier. State amendment by the Honorable High Court of Punjab and Haryana, Volume 1, Chapter 21, Rule 63, Sub-Rule 2 of Rules and Orders, High Court Notification 125, Gazette/11-Y-14, dated the 7th April 1932, number 109-R-11-Y-14, dated 21st of April 1939, number 273-R-11-Y-14, dated the 30th of July 1941. Note 1. If the court orders for publication of the proclamation in the official gazette or in a local newspaper or in both, Elmad or execution clerk shall ensure the publication is ordered. Note 2. The cost of publication of proclamation of sale shall be deemed to be cost of the sale to be firstly recovered from the decree holder and then to be included in the cost of execution. Step 8. Conducting of sale by auction. Duties or roles of officer conducting sale. A warrant of sale shall be delivered to the court auctioneer by the court through the process serving agency. The auctioneer or any official of the court who is appointed to conduct the auction shall visit the site on the appointed day. He shall formally announce the auction, shall state the details of the property to be sold, and also the reserve price fixed by the court, if any. The bidding shall then be open to the public. The last bid shall be made final at the count of 3 and drop of the hammer. Following important points are to be taken into account at the time of auction. Private sale by judgment debtor, volume 1, chapter 12, part L, rule 7 of rules and orders, and order 21, rule 66 CPC. When the court postpones the sale on the application of the judgment debtor and enables the judgment debtor to pay the decretal amount after raising such money by mortgage, lease, or sale of the property, ELMA, the execution clerk, shall issue the certificate on pro forma number 35, Appendix E CPC to the JD. We have provided with pro forma number 35, which is a certificate to the judgment debtor authorizing him to mortgage, lease, or sell property under Order 21, Rule 83 CPC. So this is the pro forma. Adjournment of sale, Order 21, Rule 69 CPC. The court may adjourn the sale to a specified date and hour. However, when such adjournment is granted by the official conducting the sale, the reason for such adjournment are to be recorded. Where the sale is made in the court premises, the adjournment can be granted by the officer conducting the sale only after obtaining permission of the court, proviso to Order 21, Rule 69, Sub Rule 1 CPC. If such adjournment is for a period more than 30 days, period of 30 days substituted for 15 days by High Court notification number 125 Gazette/11-Y-14 dated the 7th April 1932 and later substituted by Code of Civil Procedure Amendment Act 1976, a fresh proclamation under Rule 67 shall be made unless the judgment debtor consents to waive it. Stoppage of sale under Order 21, Rule 69, Sub Rule 3 CPC. The sale can be stopped if before the lot is knocked down, the debt and the cost, including the cost of the sale, are tendered to the officer conducting the sale, or the judgment debtor produces the proof of payment of the decretal amount made in the court. General rules to be followed during bidding. Bid by decree holder. The decree holder shall not bid for the purchase for or purchase the property without express permission of the court, Order 21, Rule 72 CPC. If the decree holder is granted permission to purchase the property, he shall not be required to pay the purchase money, but he shall adjust the decretal amount with the same. Bid by mortgagee. The mortgagee of immovable property shall also not bid for purchase of property except with the permission of the court, Order 21, Rule 72A CPC. When the court grants permission to the mortgagee, the court will also affix a reserve price which is to be taken into account during the sale proceedings. Bid by co-sharer, where the property sold is a share in undivided immovable property and two or more persons of whom one is a co-sharer respectively bid the same sum for such property or for any lot, the bid shall be deemed to be the bid of the co-sharer, meaning thereby that the bid of the co-sharer shall be considered and not of the outsider. Order 21, Rule 88 CPC. Restriction on bidding or purchase by officer. No officer or any person having any duty to perform in connection with any sale shall be allowed to bid or acquire or attempt to acquire any interest in the property sold directly or indirectly. Order 21, Rule 73 CPC. Step 9, receiving of sale amount, Order 21, Rules 84 to 86 CPC. In case of sale of immovable property, the person declared as successful in the bid shall pay immediately 25% of the purchase money, either in cash or check. Chief Court Notification number 2212-G dated 12th May 1909 and High Court Notification number 123-R/11-Y-14 dated 28th of April 1938 to the officer conducting the sale. In case the purchaser fails to pay immediately 25% of the purchase money, the officer conducting the sale shall forthwith issue a certificate of resale in pro forma number 31, Appendix E CPC. We again have given the audience performer number 31 in our manual, which is a certificate by officer holding a sale of the deficiency of price on a resale of property by reason of the purchaser's default under Order 21, Rule 71 CPC. The full amount of the purchase money shall be paid by the purchaser in the court within 15 days from the sale of the property. If the purchaser is decree holder, he may set off any amount to which he is entitled to. When the purchaser fails to pay the full amount of the purchase money within a period of 15 days, the amount already deposited shall be forfeited to the government after deducting the expenses of the sale. The property shall then be resold after issuing fresh proclamation. In sale of movable property, the purchase price shall be paid either at the time of sale or as soon thereafter as the officer of sale directs. On payment of the purchase money, the officer shall issue a receipt in the name of the purchaser, whereafter the sale shall become absolute. In default of payment by the judgment debtor as directed by the officer, the property shall be forthwith resold. Step 10. Deposit of the purchase money. Sale proceeds. Volume 1, Chapter 12, Part L, Rule 21, Clause 3 of Rules and Orders. The court auctioneer shall himself deposit into the treasury all sums realized at auction sales conducted by him or his staff. All sums realized at sales conducted at places where there is a treasury shall be deposited into the treasury or the State Bank of India, as the case may be, on the first working day after the sale. The district judge shall prescribe periods within which the proceeds of sales conducted at other places shall be deposited. The period so prescribed shall be reported to the High Court and shall be as short as possible. When the sale is conducted by the Nazarat branch, the purchase money shall be deposited in the court. Step 11. Disbursement of the purchase money. Volume 1, Chapter 12, Part L, Rule 12 of Rules and Orders. The purchase money deposited upon the sale of the property shall be retained in the treasury till the expiration of 15 days from the date of order confirming the sale. If the notice of appeal is received within the prescribed period, the purchase money shall be retained in deposit until the appeal is decided or unless the decree holder gives security to the satisfaction of the court to repay it at any time when he may be required by the court to do so. If no notice of an appeal is presented by the party within the said period and the court directs to pay the purchase money to the decree holder, the element shall ensure the payment to the decree holder from the treasury where the purchase money is lying deposited after the sale. The following deductions shall be made from the amount to be paid to the decree holder. Government Commission, Volume 1, Chapter 12, Part L, Rule 22 of Rules and Orders. Commission at the following rates shall be deducted from the proceeds of sale under this chapter. If the sale proceeds do not exceed rupees 5,000 at 5%, if the sale proceeds exceed rupees 5,000 at 5% on rupees 5,000 and 2.5% on the remainder. Note, if the sale is conducted by the court auctioneer, 80% of the commission will be paid to him and 20% will be paid into the treasury to the government to the credit of government. All incidental expenditure shall be met by the auctioneer. The amount of commission of the court auctioneer shall not, however, exceed rupees 5,000 in respect of any one sale. If the sale is conducted by the Nazarat staff, whole of the commission shall be credited to the government and nothing shall be paid to the officer conducting the sale. In such cases, the expenses incurred in conducting the sale, including the cost of advertisement, must not exceed the amount of commission. Expenses of custody, etc. Volume 1, Chapter 12, Part L, Rule 22, Clause 4 of Rules and Orders. The expenses incurred in the care, custody, and keep of attached property as taxed by the court shall be a first charge on the sale proceeds thereof after deduction of the commission mentioned above. Confirmation of sale, Volume 1, Chapter 12, Part L, Rule 16 of Rules and Orders. When no application is moved under Order 21, Rule 89, 90, or 91 CPC within a period of 30 days, or if made is disallowed, the court shall make an order confirming the sale. After the sale is confirmed and the direction of the court is received to issue certificate to the purchaser under Rule 94, the Elmer or execution clerk shall prepare a draft certificate and get it signed by the judge. Thereafter, the certificate in exact conformity with the draft shall be prepared in the prescribed form on the stamp paper at the expenses of the purchaser. The date when the sale becomes absolute shall also be clearly mentioned. It shall be as per convenience of Chapter 2, Part B of Rules and Orders and Article 18 of Schedule 1A of Indian Stamp Act 2 of 1899 as amended by Punjab Act 8 of 1922, Volume 1, Chapter L, Rule 18 of Rules and Orders. Sale certificate has to be on Proforma number 38, Appendix E CPC, which is also provided in the said manual. Ahmed or execution clerk shall send the copy of the certificate to the registering officer within the local limits of whose jurisdiction the whole or any part of the property is situated. The certificate is to be prepared in vernacular language with permanent black ink or with the registration ink obtainable from Central Stationery Officer, Calcutta, and on the prescribed form which is obtainable on indent from the Controller of Printing and Stationery, Punjab, Volume 1, Chapter L, Rule 19 of Rules and Orders. Handing over of possession, immovable property, Order 21, Rule 95 to 105 CPC. Ahmed or execution clerk shall issue warrant of possession for delivery to the certified purchaser of land at the sale and execution as per the order of the court and shall give it to the bailiff on proforma number 39, Appendix E CPC on proforma number 39, Appendix E CPC after the court issues the certificate of sale. Proforma number 39, Appendix E CPC under Order 21, Rule 95, which is the order for delivery to certified purchaser of land at a sale and execution, has also been provided in the manual. The said order is addressed to the bailiff, who, after receiving the warrant in the above said form from the court, shall proceed to execute the warrant and obtain the possession of the property. Any person found in the possession of the property shall be asked to vacate the property. If the person in the possession refuses to do so, the bailiff shall remove him from the property to effect the delivery of the possession. In such eventuality, following endorsement shall be made on the warrant. The property was found in the possession of A, naming the person, and that he was one of the persons bound by the decree or held on behalf of one of those persons, naming the persons, and that he was required to vacate the property, and that on his doing so, the person entitled under the decree was put in possession, or that on his refusal to do so, he was removed from the property and the person entitled under decree was put in possession. Where possession of any building or enclosure is to be delivered and the person in possession being bound by the decree does not allow the bailiff or the officer of the court to enter, the officer of the court may give reasonable warning and facility to any women not appearing in public according to custom to withdraw, and only after such warning and opportunity remove or open any lock or bolt or break open any door or do any other act necessary for putting the decree holder in possession. An endorsement in this regard be briefly stated on the warrant returnable to the court. When the property is in the occupancy of the tenant or any other person who is not bound by the decree, bailiff shall affix a copy of the certificate of sale on some conspicuous place on the property, and the proclamation shall be made as provided in the Order 21, Rule 36 CPC. The endorsement shall be made in this regard, stating the place where the copy of the warrant had been affixed and that the substance of the decree had been proclaimed. Order 21, Rule 96 CPC. Where the decree is for the joint possession of immovable property, bailiff shall affix a copy of the certificate of sale in some conspicuous place on the property, and proclamation by beat of drum shall be effected at some convenient place. Endorsement in this regard be recorded on the warrant of possession to be returnable to the court. Resistance to execution, Order 21, Rule 97 CPC and Volume 1, Chapter 12, Part Q of Rules and Orders. Whenever bailiff is resisted from executing the warrant of possession issued by the court, he shall return the warrant with the endorsement to that effect. The court shall then order to issue a summons to the obstructor to appear and answer the charge or obstructing the execution of decree. On receiving the said order, the execution clerk shall issue the summons to the obstructor on proforma number 40, Appendix E CPC, Again, we have provided the proforma number 40, which is the summons to appear and answer charge of obstructing execution of decree under Order 21, Rule 97 CPC in the said manual. If after examining the objector or obstructor, the court is satisfied that the resistance or the obstruction was caused without any reasonable ground by any person, the court may direct that the purchaser be put in possession of the property, and when he is still resisted or obstructed, the court may order the objector or obstructor to be detained in civil prison for a term which may extend to 30 days. Order 21, Rule 98, Sub Rule 3, CPC, and Volume 1, Chapter 21, Rule 72 of Rules and Orders, High Court Notification number 125-Gazette/11-Y-14, dated 17th of April 1932. On receiving the said order from the court, Elmer, the execution clerk, shall issue a warrant of committal on proforma number 41, Appendix E CPC. Warrant of committal has also been provided under Order 21, Rule 98 CPC in proforma number 41 in the said manual. Issuance of Dakhalnama. After the possession is handed over to the decree holder or any person authorized by the court, a Dakhalnama or an acknowledgement is taken in this regard. The said Dakhalnama or an acknowledgement not being an acknowledgement of the receipt of money or other movable property does not require to be stamped. The said Dakhalnama shall then be placed before the court as a proof of transfer of possession. Thereafter, the court shall consign the execution file to the record room. Handing over of possession, movable property. Movable property of which actual seizure has been made under Order 21, Rule 79, Sub Rule 1 CPC, it shall be delivered to the purchaser against receipt. Movable property in possession of a person other than the judgment debtor, Order 21, Rule 79, Sub Rule 2 CPC, the delivery to the purchaser shall be made by giving notice to the person in possession, prohibiting him from delivering possession of the property to any person except the purchaser. Elmer, the execution clerk, shall issue notice on proforma number 32, Appendix E CPC. We have again provided the said proforma, that is notice to person in possession of movable property sold in execution under Order 21, Rule 79 CPC. If the property sold is a debt not secured by a negotiable instrument under Order 21, Rule 79, Sub Rule 3 CPC, the delivery shall be made by a written order of the court and Elmer, the execution clerk, shall issue it on proforma number 33, Appendix E CPC. Proforma number 33, prohibitory order against payment of debts sold in execution to any other than the purchaser under Order 21, Rule 79 has also been provided. When the property sold is a share in a corporation, Order 21, Rule 79, Sub Rule 3, a prohibitory order on receiving a written order of the court shall be made by the Elmer, the execution clerk of proforma number 34, Appendix E CPC. We have provided the said proforma number 34, which is prohibitory order against the transfer of shares sold in execution under Order 21, Rule 79 CPC. Transfer of negotiable instruments and shares, Order 21, Rule 80 CPC. Judge of such officer as he may appoint in this behalf may execute a document or make an endorsement in the following form. Such execution or endorsement may be in the following form, namely A.B. by C.D., judge of the court of, or as the case may be, in a suit by E.F. against A.B. Until the transfer of such negotiable instrument or share, the court may by order appoint some person to receive any interest or dividend due thereon and to sign the receipt for the same, and any receipt so signed shall be as valid and effectual for all purposes as if the same had been signed by the party himself. Such execution or endorsement shall have the same effect as an execution or endorsement by the party. So this is all about the sale process as one of the mode of execution, and the entire detailed procedure has also been laid down. In the next video, we shall look into some other aspects of Chapter 4, which also deals with miscellaneous provisions. Till then, Namaskar.